Call the next case on the docket, State of Kansas versus Dominic Moore, 109480. Counsel?
May it please the court, Michael Barty appears on behalf of the appellant, and I would like to reserve 3 minutes for rebuttal, if I may.
3 minutes for reserve.
This is a co-defendant of the previous case, so we do have some overlap in issues with the previous appeal. The first issue we raised is the error in denying the defendant's motion for mistrial for what had occurred during the voir dire. We are arguing that this does constitute structural error, that what occurred here is so intrinsically harmful that it's really hard to calculate whether harmless error was met.
Now, if the judge had conducted an individual questioning of the remaining denier persons, and they had all denied being fearful, would it still have required reversal?
Well, I think it would have, and I'm looking, let me see, at Europe, which seems to indicate that it's exposure to certain information rather than a juror's reaction to it that really sets the standard. Now, in York, it was one juror, but the court seemed to say simply being exposed to that is kind of a bell that you can't unring. So I think even had there been individualized follow-up with the jurors, I would still be arguing the same thing, that this was a structural error here.
It's exposure to what?
Well, exposure to the Veneerman's argument that, hey, these guys know who I live. I'm scared. They can come after my family. These people know people. And there was a little litany that went on. And then there was some palpable reaction by the jury panel. The defense attorneys argued it. The judge seemed to recognize that there was kind of a general reaction. But none of the other members of the jury said it.
Seems to me this thing cuts more against the state than it does the defendants. It seemed to me you'd want to let these people go, because what the Venerman said was that, well, they have friends, so the notion would be even if we convicted them, they might have friends that would get us. But boy, you let them go, find them not guilty, and you're home free.
Well, I understand that, but we're jumping ahead to where these are truly dangerous people, and that's the proposition, and that's.
I'm accepting the argument at your. I'm not trying to say that what was communicated here was that they're dangerous people. It's simply the notion that if they are dangerous people, it cuts either way. And I ask the question because it's just the fact that I can come up with that perspective and you can advocate your perspective challenges me to figure out what the test is, which gets back to Justice Rosen's question. I mean, how do you articulate what it is that's enough to pull the trigger and let everybody go and start over again, as opposed to our abuse of discretion?
Well, right. I mean, there are some things that happen during the trial process that simply aren't going to reach this level. I don't think there are little things that can blow up that may result in and should probably result in a harmless error analysis on whether a mistrial should have been granted.
I'm
But
thinking of the case that I did I wrote on a few years ago, where the mother of the victim is in the back of the room and sort of stands up and says, "That's the guy that killed my baby." And we used a harmless error analysis there to walk through everything. And again, I just don't see how we articulate the test as to what it is that would constitute structural error that you want.
Well,
You're sort of saying it's pornography. We're just going to know it when we see it.
I think there's got to be some element of that. And we can flip it back and say, okay, how do you calculate whether it's harmless or not? How do you do that when it's information that causes people to have an emotional reaction. I mean, how could a court say, well, this is harmless?
And the emotional reaction would translate into what action to follow up on?
It's-
Justice Biles.
It's that same emotional reaction that occurs in cases where a jury may have been informed of someone's previous record or a 6455 error.
Well, it's not,
It's-
why, you're saying that it would not be the fear that is the problem, not the emotion, because if the fear was the problem, then the solution for the juror is to vote not guilty.
Well,
But you're saying it's not the emotion, but it's the information or implication that these are dangerous people and we need to put them away.
it is, and it's that message that is sent. And I just don't know how to do a harmless error analysis on that.
Well,
kind of
to me, it's not hard. You look first at what the judge did, and this judge talked to the jurors and explained that this is a process been used forever in Wyandotte County. I think the implication of that is used for error and forever in Wyandotte County, and nobody's ended up dead yet. And I look to the conduct of the defense counsel, and the defense counsel aren't doing anything more than making a motion for mistrial. They don't then come back and say, well, we need something curative. They don't ask for individual questions. I think if this is as bad as you say, the defense lawyers would be doing more than what they're doing because they, like the trial judge, are in the room.
But they made their motion for mistrial. And what more did they do? And let me direct you back to Blitch, because the court here tried to deal with this, and he did speak to the jury panel. And without trying to be too critical of him, it was a little more mechanical than the judge in Blitch. And I think Blitch was the one who said, factually, look, I've been doing this for years. I know all these people. I know this has never happened in our history. That was Blitch. I think the court here just kind of said, you're going to get instructions. You have to follow them. It's the state's duty to prove guilt. And even what the judge did in Blitch was determined to be error and resulted in a reversal. So I look at what occurred in Blitch and Europe, and it simply seems to me that we are at a point of structural error where we can't calculate some kind of harmlessness standard. Some rights are so fundamental that when this occurs, and this is a right to an unbiased, fair jury that we're talking about, I think clearly there's got to be some threshold of what violates that. But I don't think we can jump to harmless error and look at what other factors in the case.
Well, for example, what comes to mind is this isn't as clean as a prior crimes information coming in front of the jury because the statute prohibits that. Plus, if the defendant has been convicted of some prior bad act, then there's some sort of formality. This is just a potential juror saying, that this is a concerning factor that I'm seeing these guys look at my questionnaire where my personal information is. That doesn't even have any authority behind it, like a prior conviction. So that seems to make a difference too. And if we can have these discussions, it seems like we can have them under a harmless error when it's not something that, like prior crimes evidence, where it's just prohibited.
Well, the prior crimes assume, I guess we can cut it however fine we want. I don't know that I agree with the assertion that some official things are going to be worse than others. When we're here, we're talking about these guys being violent dangerous people who are connected enough to potentially have retribution on us. That's part of the fear.
Isn't that fear? I mean, it's not present in every case, but as the progression for more serious or violent crimes, as we go up the scale, those fears are generally present in every trial with every juror. Maybe not every juror, but many jurors have those fears about sitting on a jury, the potential of retribution, what this means for the community. And I'm trying to ferret out why this is different than any other jury panel that have those emotions, have those concerns, because I think they're present in literally every trial. But again,
Well,
as the progression goes up, you describe this case as drugs, guns, gangs, and as those get ferreted out in trial, as they're discussed in voir dire, all of those emotions come to light in every case.
Right.
And so what's different about that? I understand what's different about this is that there's a specific road to that fear based upon exposure and an address or something like that. But those are present all the time. I mean, they're always there.
I don't know that they are when somebody
Oh.
looks and says, they've got my address. I mean, I don't know that jurors are going to be thinking the defendant has my address and is going to know about me and know my family. I mean, there's a...
Maybe not that specific,
you know,
but
yeah,
possibly, but certainly the general tenor of your concern is there in many, many situations.
Well, I know jurors have some anxiety in general about doing it. This is really specific. They know me. They have my address, my family, and people know people. I mean, I don't know how you can minimize the impact of that, or how you can evaluate, how you can determine, well, that was harmless. I just don't think that it lends itself to that kind of an analysis. Jumping to issue number 2 is the denial of this eyewitness, and it looks like I'm out of time. Are there any questions?
How did you preserve that? I mean, there was several, there was a bunch of evidence that came in about that identification without objection, and we've got some pretty stringent precedent here on 6404 and King and et cetera.
Yes, we've got some problems. Now, defense counsel filed a motion to suppress, which seems to indicate that he intends to seek to suppress this identification. But he did not object at trial, as he should have. But I think that this is one of those issues that can be resolved on the record clearly. It is
Well,
a straight...
I disagree. The court really didn't make factual findings as to why the lineup was not unnecessarily suggestive. So it seems like to me we'd either have to go with the presumption that a judge makes all the findings necessary, or we would have to remand it for factual findings.
Well, right, and that's not even part of the objection problem, I think, because I don't think the judge articulated those findings.
But you said it was purely a question of law, which fits into one of the exceptions to preservation, and I'm saying that I don't see how we can say this is purely a question of law.
Well, and I'm seeking de novo review of that conclusion based on the evidence. I don't think there were factual disputes necessarily about who did what. There was some inconsistency between the witnesses. So it is difficult. I mean,
I thought there was factual dispute on how many lineups he was shown. and
yes.
When photographs got
Actually,
replaced.
there were, and I was, because we had the detective's testimony, which
Right.
was different from ground
Right.
report. So, well, yeah, I don't know how to deal with that. There were not findings of fact specifically made by the district court as should have occurred. Perhaps we could have a remand on that issue. There were a lot of problems, and I guess the second factor is that consideration of the claim is necessary to prevent the denial of a fundamental right, and that's a due process right to a fair identification procedure that Mr. Moore would have had that we argue is violated here. So that's another door to get us reviewed by this court, even though there wasn't a contemporaneous objection at trial.
Well, and you've got the issue on reliability being part of the calculus, but there was extensive cross-examination of this eyewitness, and inconsistencies pointed out, and so his credibility was certainly tested or challenged on cross-examination. Wouldn't you agree?
I do agree, but there is a due process threshold to meet in reaching that point, and that's what we raised, and this is issue number 2 in my brief. Are there any further questions? I'll submit the balance of our issues on my brief. Thank you.
Please the court, Cheryl Lidke, Chief Deputy District Attorney. I think Justice Rosen hit on something that is valid in asking the defendant about the implication that in many juries may have that defendants are somehow bad people or dangerous people, that it is almost implied. Jurors often must be thinking about this just when they come into a courtroom and find out that they're sitting on a first-degree murder case. Somebody in front of them is accused of committing a first-degree premeditated murder, and in this case, a second murder and an attempted third murder. Probably a lot more than just the one Veneerman was concerned about these people being bad people or dangerous people. But that's not the standard that we look at in resolving this issue. This issue is resolved by your asking yourself, would another judge, would any reasonable judge have come to the same conclusion and acted in the same way that Judge Burns did? Did the judge make correct legal conclusions, and are his findings supported by the evidence? And again, we're here to ask you to find that he did not abuse his discretion and answer all 3 of those questions in the affirmative. The defendant says, how do you minimize the impact once a jury has it in their head? Well, the way you minimize it is exactly how Judge Burns did, which is he immediately instructed them that as the defendants sit here, they are presumed to be innocent. The state has the burden to prove their guilt beyond every reasonable doubt as to the elements with which they're charged. It is also their right to have a jury trial. That's why all of you have been summoned here to come down here and go through this process. And then he went on to talk generally about the questionnaires and what we do with that information. But that's how you minimize the impact, is you immediately respond to the concern and instruct the jury, remind them that they're here to base a verdict on the evidence alone and not about their concerns for their own safety. But as I argued before, there simply is no evidence that anybody but Veneerman W. had any concern for his safety. And shouldn't we have to have more? Shouldn't the defendant have to show you more than just a gut feeling that the rest of the panel also had concerns for their safety? The record contradicts that. As I pointed out before, the judge said that he did not notice any other jurors expressing their concern, that they had ample opportunity to do that. He didn't even notice any of them moving around as if they were anxious about that issue. So the record supports the state's position in this. Clearly does not support the defendants.
Can I move you to some of the other issues?
Sure.
Would you agree that the eyewitness cautionary instruction was erroneous under our current law?
Yes, after this trial was done, the current law said that it was improper to put the level of certainty in as a factor for the jury to consider. That was error, but as I point out in my brief, there was no evidence about the witness's certainty. The only evidence that was brought out about Mr. Ford's certainty when he identified Mr. Moore was by the defendant himself. he asked Brandon on cross-examination, were you positive when you made that identification? That's the only time anybody asked
Why
Brandon
isn't that,
about,
why isn't that certain?
well, that may be, but that's invited error. Why should he be able to bring that out and then complain on appeal about it?
So that's different than being no evidence. It's invited error because it was solicited by the defense, is your argument.
That's correct.
Can you invite an error you don't know is error yet?
Well, that's a good question, because as I said, that the cases that said that that was an improper factor came out afterwards. I just don't think it's fair to hold it against the state, though. The state didn't draw out any of that information. And so to say that, yeah, we're asking that you find that it was harmless error. Even if it was, if you find that it was error, and I am conceding that based on your later decisions, it was error to include that as a factor. The fact that there was some evidence put on by the defendant really is only one of the considerations when you determine whether the error was harmless. As Justice Johnson has pointed out, the defendant was zealously, the witness was zealously cross-examined about his inconsistencies. The defense made a great deal of his inconsistencies in their closing arguments. The jury was given an instruction about reasonable doubt, and there was strong evidence outside of the lineup identification that Brandon Ford identified Mr. Moore. He had said so to some family members, and he identified him in court as well. I wanted to get back to the second issue, which was touched upon briefly by the defendant, regarding the lower court's refusal to suppress the lineup identification by Brandon Ford. Our position is that this issue is not properly preserved because there was not an objection at trial. As you guys have looked at the record, you know that the only time that it was raised was before trial at the motion to suppress. When the actual evidence was put on, the defense did nothing to object to it. Even if you think it had been properly preserved, there was substantial evidence to support the court's findings that Brandon Ford's identification was reliable, and the court's legal conclusions on that were correct. Our argument is that if there's a lack of specific factual findings by the court, then that's the defendant's problem as well. This court has repeatedly held, even as it relates to constitutional issues, that it's the defendant's obligation to make sure that the lower court makes the findings that are necessary to take the issue up on appeal. This defendant didn't do that. His only complaint about the lineup at the suppression hearing was that Brandon had been tainted because he had seen a single photograph of the defendant wearing a red shirt that was somewhere on the detective's table, and that is what caused him to later pick him out in a lineup. But that complaint was not borne out by the evidence at trial. Detective Slater was absolutely positive that that photograph could not have been shown to Brandon before he showed Brandon the lineup, because he only got it after Brandon had identified Mr. Moore in the lineup. And he did so because it was a more recent photograph, and he wanted just to make sure that he had the right person in the lineup. So the complaint that he had about the right reliability of the identification is not supported by any of the evidence as it turned out at trial. Furthermore, the likelihood of any misidentification did not exist. In our opinion, there were ample other procedural safeguards that protected the defendant on this issue. We had a full-blown hearing. He had an opportunity to have a full-blown hearing on his motion to suppress. And as I stated earlier, there was zealous cross-examination of Brandon on this issue. And the judge did give the jury a cautionary instruction on eyewitness identification. So even if you find that there was, this issue was properly preserved. We believe that the judge's refusal to suppress the line of identification should still stand. The third issue involves the request for mistrial when Brandon Ford testified differently than he had previously testified at the preliminary hearing. The defendant claimed that a Brady violation might have occurred because he changed his story, and the state must have known that he was going to change his story. That simply is not borne out by the evidence either. A clear review of the record.
Didn't the district court specifically find that the state was not aware that the testimony was going to?
Yes, and that was after the defendant himself said, "I don't believe the state knew about this." There was just no evidence at all to suggest that the state was aware that he was going to change his testimony. And as an example of that, in my opening statement, I told the jury that Brandon was going to say that he was in the bathroom when this happened. Obviously, he ended up saying something different. Why on earth would I say that to a jury in my opening statement when, in fact, he ended up saying something different? I mean, so that's just an example of why you should be persuaded that the state did not intentionally hide something that it had a duty to disclose to the defense.
Can I ask you on the, move you over to the chain of custody issue? The objection came when the Glock was proffered for admission. Does it matter that there had been some testimony about this handgun before? Or do you in other words, you have to object to a chain of custody at the time an officer wants to testify about the weapon?
No, I don't think that an objection about the physical piece of evidence coming in is necessarily negated by the fact that there's already been evidence about that piece of evidence.
But here the Glock was tested for DNA, right?
Correct.
And
And
I mean, we
ballistics.
had the ballistics tying it, but it was in a house for both defendants. So, tying it to Mr. Moore was the one out of 43 people, minimal kind of DNA, right? That tied him to that. There was no DNA. Mr. Moore, there was none of Mr. Warren's DNA, correct?
Right, there was nothing that was consistent with Mr. Warren's DNA on it. And I wanted to clarify about the DNA evidence. It wasn't that they were able to come up with the whole profile and that the statistics were so low because it was a very common profile. It was that there wasn't much DNA there to start with. And so it was just a partial profile. And so even though the statistics...
the point is what made the testimony about the weapon important in this case is that Mr. Moore could be tied to that weapon. And the testimony tying him to the weapon seems to me that chain of custody would be important in that respect. I'm just trying to get, if you have someone testify, we found this gun and it had defendant's DNA on it.
Sure.
Now we're going to proffer the gun. Oh, well, then chain of custody. But if there's a chain of custody problem, wouldn't that relate back to what the relevance was?
Sure, and I'm not suggesting that chain of custody isn't important. I'm just saying it's not so important in this particular instance that it requires reversal.
Where I'm getting at is do we have a preservation issue here? Because we had a bunch of testimony about the gun before we ever had an objection on chain of custody.
Right. Again, I don't think that the fact that I'd already presented a lot of evidence about this gun would preclude him from then lodging an objection about the physical evidence. But it goes to your analysis about whether it's reversible error or not. The fact that there wasn't an objection to a lot of other evidence that was basically the same kind of evidence about this physical piece of about this gun, that the prejudice in not putting in one or two people who may have handled the gun in the chain of custody was very minimal. So, the other issues I will also rest on the brief, unless there are any other questions.
Thank you.
Okay, thank you.
And I think on the issue of Brandon Ford's changed testimony, I think that he testified that he had told the state about this changed version of what had occurred. And that was the basis for the motion for mistrial and the Brady issue that I raised. I think Ford himself testified. I told him back in February that this is what had really happened. Regarding the objection to the Glock and the physical evidence, we recognize that defense counsel did not object to the evidence derived from testing of the Glock. But it should not have been presented to the jury without an adequate chain of custody being established on the gun. And there really wasn't a chain of custody here. There was just kind of a narrative. The gun was pulled out of a van. The KC Mo Police Department took it. And then at some later point, someone from the Kansas City, Kansas Police Department picked it up.
Well,
And here it is.
I guess I understood the testimony differently, that the Kansas City, Missouri law enforcement officer testified, took the gun, put it in their evidence area, and then Kansas City, Kansas came over and picked it up, took it to Kansas City, Kansas, and locked it up in their evidence area. What more would have to happen?
Well, I think that actually happened after the objection was made and was overruled when the gun was admitted. I want to say that, because I think there was an objection to the gun when it was offered, and there was really nothing at that point.
But let me get you to answer this question. If that was in fact, and the record's going to speak for what the record is, if the testimony was that the officer discovered it in the duct work, took it to the Kansas City, Missouri evidence area and secured it, and then it was picked up by a Kansas City, Kansas officer who returned to Wyandotte County and locked it up in their evidence area, was there anything else that needed, would that be sufficient for a chain of custody?
I think so. If they establish it wasn't tampered, it was locked securely, and those kinds of things. The issue on the photo identification suppression, Brandon Ford testified, and he described a number of irregularities that should raise our concern about the validity of the process that was used. He testified about being shown, and said that he was shown an actual color photograph of Mr. Moore in our case. I believe the detective testified that it did not happen. He would never have done that, but then admitted that there was apparently a color image of Mr. Moore somewhere, and he thought that perhaps Mr. Ford might have seen that inadvertently. But Brandon Ford talked about there being separate processes, separate lineups. He testified that the police wanted to show him, I think, a new photograph, a color photograph of Mr. Moore in the case. He testified that the clothing, that this photo actually contained clothing rather than a typical blanket that they use when they're showing someone a photo array, and he noticed that that was unusual. He thought it was strange that the color of the clothing matched what he had
But
described.
what are we reviewing? I mean, those arguments were made to the trial court. The trial court made its finding. Are you saying that the trial court's finding wasn't supported by substantial competent evidence?
Yes.
or-
And what I'm actually asking is because there weren't those findings, that this court do de novo review. If it declines to do that, then find that there was no substantial evidence to support a finding that the procedure here was reliable. There is a threshold of reliability that's got to be met here. Another issue that Ford talked about was being familiar with other people in the photo, which would seem to really dilute the validity of a photo lineup. If you're looking at strangers, you would at that point be able to at least compare one person's features to another. If you're already familiar with the other people, that seems to undermine the validity of your determination that the subject who did this is not one of those people. We usually assume that lineups are all unknown, that the people in them are all unknown to the witness. But listening to Brandon Ford's testimony, that didn't seem to be the case here. He seemed to indicate he recognized a bunch of these people.
And then that all tainted his in-court identification?
Yes, I think inherently it would have.
Because he did identify him in court, did he not?
Yes.
Further questions? Thank you.
Thank you.
The court will take this matter under advisement. We'll call the